The January 6th Capitol Hill cases are still working their way through the justice system. And yeah, some of it is sort of justice and some of it probably isn't. We've been seeing a little bit of a different tier of justice for the Capitol Hill defendants. If you've been a part of this channel for some time, you know we've covered a lot of social, societal unrest, and we've talked about certain stories where we take a look at some people who are in sort of the Antifa BLM bucket, and we look at their case dispositions, and it seems like they get diversion deals. They don't go to jail. They get released out on own recognizance release with no problems at all. But then when we change gears and we sort of hear from some of these Capitol Hill defendants, it's a bit of a different story. And the Epic Times today came out today. We're talking about this guy. Name is Richard Barnett. His case is still working the way through the court system. Of course, here he is in this infamous photo sitting in Nancy Pelosi's in her desk on her chair. And he's a retired firefighter. He's from Arkansas. And let's see here what's going on. So he is now accusing the feds of multiple constitutional violations. So this article written June 29, 2021 by Mark Tapscott. He's a retired firefighter. He was in this photo with pictures of his feet on Pelosi's desk, and then he later surrendered to the federal authorities. So given federal pre-detention law, as well as his explanation, let's see here, he could reasonably have expected at worst to be restricted to his home while awaiting trial, right? Sort of given the nature of the charges. And that was initially what Barnett received from Judge Eric Weideman of the U.S. District Court following his voluntary surrender on January 8th, right? So he goes in, there's a lot of chaos. A couple days later on January 8th, he goes into the FBI agents and voluntarily turns himself in. But in a unusual move, according to this article, the U.S. attorneys now successfully then petitioned the U.S. District Judge, Judge Beryl Howell, to reverse Weideman and then jail Barnett in the District of Columbia, pending trial on 7 charges that, if convicted, could result in fines against him of nearly $400,000 and put him in prison for more than a decade. So as a result, Barnett was kept locked up in a D.C. jail until late April, right? So from all the way from January 8th to April, so 2 months in custody, one of more than 500 individuals arrested by federal authorities in connection with January 6th, many of whom still remain in detention. So Joseph McBride, veteran public defender, finally got some success, got him released. He's going back home, went back home in April. And so his trial has not yet been set to begin. So this was a motion. Let's take a quick look here. Looks like this was filed back in April. So we've got the defendant now respectfully moves this court pursuant to the Bail Reform Act to release him on his own recognizance. So this was filed, it looks like, back in May. Alternatively, the court, if they're not amenable to releasing him on his own recognizance, then they want third-party custody. The defendant states the following in support. All right, so that's just sort of a quick headline there. It says the law is clear. Only in a very certain limited set of circumstances is pre-trial detention acceptable, is their argument. At first glance, Barnett is charged what sounds like serious felonies, right? Tier 1 domestic terrorists, a ticking time bomb is what they said. But on closer examination, he says the charges don't really match. The quote, the dangerous weapon that's there was an inoperative stun gun. It was a walking stick, right? Federal property he's accused of stealing was a single unopened envelope he took on Pelosi's desk, which is still, I'm not endorsing any of this behavior or not, but is this, the crime of the century, or is this something less? He is charged with illegally entering the Capitol. Barnett claims he was swept into the building by a crowd and only entered the quarters in search of a bathroom. He says he is enticed to pose for the desk photo by a news photographer. McBride's second argument says that they treated him seriously, didn't match any prior cases. Despite being charged with multiple crimes, they say that he was released on bail. Okay, so here's the government now opposing the defendant's motion. So he said they open up their opposition to this motion, filed a couple days later. They say, Nancy, Big O was here, you B-word, right? So that's the language that they're sort of using to oppose his bail release, but it sounds like he's made bail anyway, so he is home. That's what we've got for him. His trial is not set yet, which is curious. So we'll see where that is. Now we're going to change gears. Let's talk about Jacob Chansley. Remember Jacob Chansley? I didn't throw a picture on this slide, but Jacob Chansley was the guy with the bullhorns who was sort of walking out with, I think one of his friends took the podium, which means you get to control America if you have that thing. And they took a bunch of those ridiculous photographs, and his case is still working itself through. And I was a little bit agitated with his case because when the government asked for a 60-day continuance, remember this, they were not releasing these defendants out of custody, just in general. You're an insurrectionist, you're a terrorist, you're going to destroy America, therefore we cannot let you out. And I'm going, what? This person has no criminal record at all. Some of these people were not even there on the Capitol grounds that day, and the judges were still just acting like, I don't know. Whatever. Children in terms of their temper tantrums that they were throwing over these cases, because it was so far removed, I think, from reality, how they were categorizing the actions of these people relative to what actually happened, right? So anyways, the point here is they would not let Jacob Chansley and many other similarly situated defendants out of custody because they were so dangerous. Then the government, because they're incompetent, turns around and says, well, we can't actually prosecute all these cases in time, so we need continuance. We need extension so we can actually do our job. And they were asking for like 60 days. And I think, if I'm not mistaken, Jacob Chansley's attorney actually sort of didn't oppose that, right? Just said, oh, okay, yeah, no problem at all. If you need a continuance, no problem. And that irritated me because I'm thinking, well, if they're not going to let him out of custody, then he's just going to sit in there while the government just sits there twiddling their thumbs for another 60 days. Justice delayed, I say, is justice denied. They've got to make sure that they're moving this forward, or let him out of custody. It's one or the other. Get a continuance if you need it, but let him out. They didn't do that. All right, so let's check in now and see what's going on with Chansley's case. Here is the first status update. And this is interesting. This was filed a couple days ago on June 26. It says, Jacob Chansley, the government now submits this status update pursuant to a previous filing. Since the last status update, the defendant has been housed at FCI Inglewood in Littleton. So he's still in custody, right? He's there. And he's going to undergo his competency evaluation. And the parties have been providing appropriate information to the evaluator, all right? So what does that mean? Competency. Okay, we talk about this a lot, right? You have to be competent to stand trial. Loosely speaking, it's the idea that you know what's happening against you, right? You're aware of what's happening. Judges will often ask, do you read and write English? How far did you go in school? Did anybody coerce you to appear here today? Did anybody promise you anything that is getting you to do what you're doing here today? Do you read and write English? Do you understand what's happening? Do you have any questions? They want to make sure that you're competent. And sometimes there are people who work their way through the justice system or have unfortunate interactions with the justice system that are not particularly competent, right? They may be, off of medication. They may have some psychological disorders. They may have been abused or traumatized as children or kids. They might have some serious psychological conditions that need some help. And so it sounds like he's going through that process right now. And the way that this works, at least here in Arizona, is when we go through this, it's sort of, we bring in multiple experts to do a proper evaluation. So the way that this works is there's typically a list of court-approved specialists who can weigh in and determine whether a person is competent or not competent. And what they will do is they'll sort of do a clinical evaluation, right? That defendant will come and meet with that one doctor, and that doctor will say, well, okay, competent or not competent. Sometimes people will say that I'm not competent in order to sort of think that they can escape out of a criminal charge. And so these people are pretty well trained to sort of identify actual incompetencies versus faux incompetencies. And so they'll go through that analysis. And typically the way that it works, at least here, is they'll see two different providers. If the two providers agree on a conclusion, they say, okay, hey, I met with Rob. He's a loony. I met with Rob. Also, yeah, I agree with you. He's not competent. So what we'll say is, okay, they're in agreement, and so we don't need further inquiry. They will then submit their perspective to the courts, and something else will happen. We'll move that person kind of out of the criminal legal track and into a restoration track where they can go get treatment, medical care, be restored to competency, and then we can decide what to do moving forward, with the criminal case, if that should be something that still moves forward. We don't know yet. But there are other situations where if you go see one specialist, one expert, and they say perfectly competent, you might see another one, he says, no, totally not competent. Now what you have to do is get a third person to break the tie. And so these things can be actually pretty involved. You go to a third doctor, whichever way he goes, that's where the court will tend to find, and you have a hearing and present all of your arguments and all of that stuff. So it can turn into actually a big, long, drawn out process. And it sounds like they're still sort of in the middle of that right now. So when we go in now, there was another motion that was being submitted. They do want to see if they can dismiss one count, which is count 2 of the indictment. So this was a little bit interesting too. Essentially what they're doing here, let me frame this out just a quick minute, is they're taking a look at the indictment, right? An indictment is something that the government presents to a grand jury. They say, hey, we've got these facts here, and we have the list of the laws. So we say this happened. There was an insurrection that happened on January 6th, and we also have these laws. And what we want you to do, grand jury, is sort of compare the two and tell us if you think a crime was committed. Say the law says you can't do this. Here something happened. Do you think that was violated? Yes or no? Great. Yes. So the jury, of course, came back on all these, indicted all of these Capitol Hill defendants. And then once the attorneys now, because of course all this happens behind closed doors where we don't get to see any of that, client gets charged, they hire an attorney, we take a look at the indictment and we say, that's what they presented? Okay, well, we don't really even know what that means. The defendant is, the indictment is saying, well, you interfered with governmental operations. And you're going, well, there's a lot of governmental operations that are going on at any given time. Which one are you talking about? Because we're defendants, and I need to know specifically which one you're talking about. Now, we all know they're talking about the counting of the electoral votes on January 6th, but it's still sort of this missing gap. And what the defense attorney here is saying is, look, there is not enough information in the indictment. It's facially insufficient for this to be brought against our clients. And until there's more information, we can't even prepare our defense. I mean, really, we don't even know what they're talking about. And so what he's doing is he's sort of drawing out some of these differences. And it is a little bit interesting. It's going to feel very like we're running through minutia, talking about little different things that really kind of don't matter. But I want to show you how this works. One second. All right. So let's take a look at the actual motion now. So this has been filed by Jacob Chansley's lawyers in the U.S. District Court for the District of Columbia, filed today, June 29th, page 1 of 2. Two quick motions, or 2 quick pages. It comes now, Jacob Chansley. And just remember, this is not a motion to dismiss the entire case, just count 2, right? Just one count of the other counts. So here they're saying Jacob Chansley, the defendant, is now moving to dismiss this one particular charge based on the Constitution, rules of criminal procedure, 5th Amendment, 6th Amendment, U.S. Constitution, etc. Why? Why are they saying this is appropriate? Here's why. Count 2 of the indictment says that on January 6th, quote, he attempted to and did corruptly obstruct, influence, or impede an official proceeding. And that is a proceeding before Congress by entering and remaining in the U.S. Capitol without authority and committing an act of civil disorder and threatening congressional officials and unlawfully remaining in a restricted building without lawful authority and engaging in disorderly and disruptive conduct in violation of U.S. code. Okay, so you see how that works, right? So if you're a defense lawyer, you take that sentence and you just start separating it out, right? You just take these words, you say, okay, a proceeding before Congress. Okay, well, they've got to prove that. They're saying that he violated the law here and that he did something wrong in front of a proceeding before Congress. So they got to define they've got to prove that. What is a proceeding before Congress? And they're going to say also another element of the offense is entering and remaining inside the U.S. Capitol without any authority. All right, well, so what does without authority mean, right? Do they say that he was refused entry? Because we saw a lot of videos of people the cops say, hey, come on in. I disagree with you, or I disagree with you, but I support you, or something like that, right? Some weird statements going on. So what does without authority mean? And so you can see here, like, there's a lot of gray area that a defense attorney is just going to latch into and say, well, I need to know what you mean there specifically, because I'm looking at this indictment. My client's denying all of this stuff. I don't even know what you're talking about. I need to know the specifics so that I can specifically refute those things. All right. Carrying on, it says count 2 must be dismissed. So now we know what the problem is. We know what the law says. Now we're seeing why he wants it gone. He says count 2 must be dismissed. This allegation fails to state an offense. Also, fails to provide Chansley with adequate notice of what he's even being charged with, does not ensure that a grand jury had found sufficient evidence of necessary elements of the offense under the Constitution. All right, so he's saying that when this was presented to the grand jury, they're looking at it and they're going, I don't know. I can't even possibly come to a conclusion because it is so vague. We don't know what you're talking about. Carrying on, he says, more specifically, the indictment fails to state specifically what an official proceeding is, and even more specifically what, quote, proceeding before Congress Mr. Chansley allegedly obstructed. Says the critical issue in this case, because US 18 only prohibits obstruction of an official proceeding related to the administration of justice before a tribunal, and not any and all governmental functions like legislative action. See how that becomes suddenly quite important there? We need to know what proceeding before Congress was obstructed, because the law that you referenced, that you charged him under, doesn't say anything about interfering with a congressional governmental hearing as problematic. In fact, it's for something else. It's an official proceeding related to the administration of justice before a tribunal, right? Which would be more analogous to a criminal proceeding, something that was the administration of justice, not the election of the next president, right? So maybe that law just doesn't apply at all. Moving forward, we can see here we've got a memorandum in support of this. We'll just take a, I just want to show you what this looks like. Comes now, introduction and background, right? So they're going to go through. Here are the different counts, count 6, count 5, count 4. The only one he wants gone is count 2, obstruction of unofficial proceeding. So that one, we'll see. I'm going to guess the judge says, oh, no, this is too serious for due process. You try again. Let's take a look over at watchingthewatchers.locals.com, jump into some questions. And before we move on to the next segment, let's see who's first up in the house. We've got Tim Flynn. Good to see you, Tim. Says, with so many police resigning and retiring early, there must be many openings. Would a campaign to hire more black officers to work in predominantly non-white areas help with racial issues and distrust of the police? I saw a department hosting a basketball tournament along with a career fair. No joke, maybe a good idea. I campaign to hire more black officers to work in predominantly non-white areas. So, listen, I'm open to any and all ideas. If that is really, something that would move the needle in a positive direction, I think I'm totally open to exploring those ideas. Now, look, I know that this typically doesn't win me many friends here, but I've seen law enforcement not necessarily be, okay, let me be careful here. I've seen law enforcement officials in my career be overtly racist, right? Be overtly, a white guy against a black guy. Absolutely seen that. I've seen it the other way, right? I've seen in my opinion, to be black officers that are sort of, overly harsh towards white defendants. I've seen that. Do you know why that is? Because I've seen it every which way, every cross-examination, every permutation of garbage law enforcement interactions with society. I've seen black cops on Asian people. I've seen black cops on black cops. I've seen black cops on white people. I've seen white cops on black cops. I've seen it all. I've seen every single one of them. And so, my perspective has always been that it's about a cultural problem with law enforcement to some degree, right? To some extent. Not saying that the entire thing is problematic and we got to defund the police and throw them out. I've never said that. But I do think that there is sort of a culture where there are a lot of officers that are predisposition. They have a predisposition to sort of treat certain interactions in an aggressive manner that doesn't justify that response. The situation doesn't warrant the type of response. But there's a video here of an African-American officer with an African-American defendant here in Mesa, Arizona. And the guy has been told, the defendant is totally surrendering, right? He's got his back up against the wall and he's not fighting in any way, shape or form at all. And so what this officer does is when he sort of refuses to comply, he just starts beating him in the head, right? Just beating him right in the head. I'm not sure what happened with that situation, but my point here is it can cross boundaries. It can cross demographics, ethnicities, races, everything. And so I'm not sure that would solve the problem, right? I don't know if that's going to be meaningful, but I'm open to it. We've got Tim Flynn says, what do you think about community police oversight committees who review complaints against officers and use of force incidents? Are they effective in keeping departments and officers under control without crucifying them for reasonable actions? So community police oversight committees, I can't speak to that, right? I can speak to certain attempts at creating these things. I mean, I don't have enough experience with them. I'm not sure that there's there is truly that much oversight going on that I've got experience with, right? Most of the time, what ends up happening here is it's sort of the law enforcement agencies investigating themselves. So you could, in Arizona, for example, we've got all of these different law enforcement departments, right? It's different city agencies. We've got Glendale, Mesa, Phoenix, Scottsdale, PV, all of them. They've all got their own enforcement agencies. And so they've all got their own little, mechanisms for how they regulate themselves. Some of them debate these bigger oversight committees, like the city of Phoenix had that conversation for some time. They always create these councils and these committees and all of these different things. And what ends up happening in my experience is they sort of investigate themselves and they find they did nothing wrong. And then we have this sort of loosely overarching statewide organization called the Arizona Post, Police Officers Safety and Training Board, whatever, right? So they're supposed to be the group that certifies the police, and the whole thing is largely, lacking transparency, almost no accountability. It's sort of like a political arm of law enforcement, and that's about what we've got, right? So I don't have much experience with actual oversight committees, and I really don't know much about what that would look like here. I am open to the idea, but at the same time, right, it's sort of one of these concepts where you go, I'm not so sure that is a real good solution either, because a lot of bureaucrats in general don't know much about anything. I mean, candidly, they come out there and they think they do, but if you put one of them in charge of one of these boards, yes, maybe you get a different perspective on it, but you certainly don't want to turn it into a situation either where it's all a bunch of defund the policers on there, right, where every single solution is just to defund the police, because that wouldn't work either. Good questions there. Very heavy questions there, Tim Flynn. Thank you for those. And I could talk about these topics all day. I appreciate that. And we'll save some for later though. We've got ZZ the Boxing Cat says the people from January 6th are denied 14th Amendment rights. How is that even possible? Where are the Republicans? Nowhere. The Republicans have just been asleep at the wheel with all the Capitol Hill stuff. Same thing that the Democrats are doing with defund the police. They're just running the other direction. So are the Republicans with the Capitol Hill stuff. Same with a lot of attorneys, actually. It's been an embarrassing sight to see that you have defense lawyers and you have certain people who are all about free speech and due process and civil liberties and all of this stuff just say, unless they're Trump supporters, unless they were there on the Capitol building on that day, then they're a little bit too toxic for us. We don't want anything to do with them anymore. We have LT13 now says, did you see the 60-year-old something woman who just got arrested this week and had a picture of the police literally holding the door open for her? She had toured the Capitol 5 days earlier. No, I didn't see that one. No, but it is. It's the 60-year-old grandmas that the FBI is, hyperventilating about every day. We've got E. Dantes says, I've said this before, but as egregious as the behavior was on January 6th, there was not a threat to our republic. Obviously, yeah, you're right. But they did take the podium, which is, I think, the center of power here. The specific set of politicians are not the essential to the continuation of the republic. If all these reps and senators completely disappeared peacefully, it would take about 4 weeks for the deputies next in line and the new elections to restaff the government. We would be up and running. Yeah, I totally agree with you. I mean, would we even skip a beat? I mean, we sort of have ineffective leadership and gridlock all over the place. Could we just replace all of Congress and also have incompetence? Sure, could do that, no problem, easily. Thunder 7 says, Rob, I looked at the 65-page list of people arrested but not convicted. There are over 500 with over 400 charges with curfew violation. That's it. What is that? They were trespassing. That's it. No violence were invited in. How can this be legal in America? Is it? Can they sue for political persecution? No. And how many of those arrested for violence were Antifa? It's just all great questions there, Thunder 7. All great questions. I'm not laughing at the questions. I'm laughing at the sort of the accuracy of it, right? How can this be legal in America? I ask myself that question all the time. It is, right? Because we've got a lot of people in control with the levers of power that are able to do these things. It is a wild scene, isn't it? I share your frustration. I don't have a very good answer for you. Curfew violations. Yeah. I mean, we've talked about them here. We talked about it right after it happened. There were 2 cases. I think 2 of the defendants showed up. One of them showed up the night after or the day after. Wasn't even there. Got charged, got rounded up in the media, Capitol Hill protesters, pictures all over the place, and no bond and all of it. Wasn't even there. Absolutely a political I think, politically oriented prosecution, but because they have a legitimate basis in it, because they can tie them to some actual criminality, unless they do something a little bit more egregious, things like prosecutorial misconduct, they require a little bit of a higher bar there. We've got last one on this segment says, No Doubt says, how do the riots in Portland relate to that law? Does insurrection not apply because they only rioted and tried to burn down the building after hours? It seems like if they were successful, it would interfere with the next day's tribunals. Yeah. They're kind of making this up as they go along on this one. And I mean that candidly, because during Attorney General Merrick Garland, remember when he was getting confirmed, I think they brought him in front of the Judiciary Committee, in front of the Senate, and they asked him about that. You keep using this word insurrection. What does that mean to you, Attorney General? Since you're going to be the head of the Department of Justice, you're going to be somebody who's enacting policies throughout our country. How do you define insurrection? And he specifically said something about the timing, right? That it needed to be like in the middle of government operations, interfere with something that was happening, which of course would apply to January 6th, but maybe not apply to much of the Antifa or the BLM people, right? Sort of creating a line that protects one particular ideology at the expense of another. Because the Trumpers went in during the daytime when it was open, and everybody else was doing things at night when things were closed. So he can distinguish the cases, which is clever, but disingenuous. Last up, we've got Hack Consulting says, would political persecution fall under hate crime laws? So typically, so I'm not sure that there's any criminal statute for political persecution. The more common way that you see it would be like a militia. So rather than political persecution, we would be talking about prosecutorial misconduct, right? Prosecutorial misconduct would be the different way to frame that. So it's prosecutors then who are pursuing criminal charges with no probable cause or for an ill motive. They've got an illegitimate basis for bringing charges against somebody. They're doing it maliciously. And it's hard to prove that here because you have to have a pretty high standard for that. Here, the judges agree with the prosecutors. They're all DC swamp people, right? They're all just sort of in this big bucket of gross. And all they do is just sort of, support one another. Oh, I'm a prosecutor for the U.S. Attorney's Office. This was egregious, Your Honor. This is something, a reprehensible democracy, America. Oh. PTSD, AOC. Judges go, oh my God, you're right. I'm really sorry, Mr. Prosecutor. You're right. This was a tragedy, travesty, worst event ever in America. Forget 9/11, Pearl Harbor, or anything else. And so and the defense attorney's going, what world are we living in here, folks? Can you grow up a little bit here? Okay. It was like a 2-hour trespass problem, right? For this client, not everybody, but individually speaking, you can separate them out. Not everybody is an insurrectionist that's responsible for ruining America. Now, if somebody is facing criminal charges that resemble those, our law firm can help. R&R Law Group, we're located in Scottsdale, Arizona. We have an amazing team of people that can help with any of these types of criminal violations that you see here on the slide. Things like felonies, traffic violations, drug charges, DUI charges. We can help remove old mugshots off the internet. We can help you clear up a criminal case record so that you can restore your rights to vote and possess a firearm again and sort of get things back on track a little bit. We would love the opportunity to help. We're very passionate about this work. We offer free case evaluations at 480-787-0394 or click this QR code, take a screenshot, take a picture of that QR code. We'll take you right on over to our website. If you're not interested or you don't need a criminal lawyer, that's good, but you may want to learn something, and you can do so by going over to gumroad.com/Robert Gruler, where you can pick up a copy of Law Enforcement Interaction Training, a 2.5-hour program where I teach you the 1-2-3 rule for dealing with the police. Very easy. We condense and consolidate all of the complexities of criminal law into a simple rule: 1, 2, 3. Go check that out. It is some good stuff over there. And as always, thank you for your continued support here and at watchingthewatchers.locals.com. Thank you for those great questions.